how does an uncontested divorce work? Hi, I'm Bill Farias, founder of Farias Family Law, and we got this question last week. We have a gentleman who is moving toward divorce, and he thinks he's in agreement with his wife on what they're going to do with the children, how they're going to divide their assets, and how they're going to handle support. So what I'm going to explain in this video is how the uncontested divorce process works. And let me be clear. Any case that is filed regularly or contested can become uncontested once the parties reach an agreement. But I'm going to set that aside for now and talk to you about an uncontested divorce case start to finish. So the way that this works is that, first of all, you need to figure out what terms make sense, what terms are fair, what will actually be in your divorce agreement. And the first thing that I'm going to encourage you to do is to figure out where you are on the risk spectrum before nailing those terms down. And what I mean by that is the longer your marriage, the more money you have on the line in terms of assets to divide, potential support to pay, and if you have children and parenting time is an issue, then you are moving closer, or you are closer to the higher risk end of the spectrum. And if you have any type of significant risk, then what I recommend you doing is talking to an attorney to figure out what you are entitled to and how you should approach it before nailing down the terms. And again, it depends on where you are on the spectrum. If you have no kids, short-term marriage, not much to divide, then you may not need to do this. But as you move down the spectrum, longer marriage, more assets, more money on the line in support, kids, then you want to get this analysis done so that you can figure out how you want to approach this, what you want to look for, what you want to ask for. And you want to do that before you start talking to your wife or husband about the terms of the agreement. When you do it backwards, it becomes more problematic. If you are first talking about the terms and making certain statements that are creating expectations in your soon-to-be ex, then it becomes difficult to then, if you figure out that that's not in your best interest, to go back and try to undo that. Then it can get really messy. So before you start talking terms, if there is any amount of significant risk, then invest in just talking to a lawyer about where you're at and how you should approach it. So that is step number one, is figure out whether you would benefit, even if you're going uncontested, right? Even if you don't need a lawyer representing you for an actual case, you need to figure out where you're at and you need to figure out what your rights are and how you should approach it. Then once you have that info, you will be in a better position to make an educated decision about how to resolve the case, right? So a lot of people have this misconception that if they lawyer up, then that means it's World War III. Not necessarily. And that's not the case in many cases, because what you're doing is just educating yourself. Then what you do with that information is up to you. If you want to give a little bit more here, if you want to be flexible, which you should be, you can do that. But have the knowledge and education before you go into negotiations. Once you have that information, right, then what we typically do with uncontested cases is we make sure that all of the terms are nailed down, right? So what we'll do is we'll typically send information to the client about everything that they need to address in the divorce agreement. And that way they can have a conversation with the spouse to make sure they are in agreement. If you're going to go down the uncontested road and actually approach it uncontested from the outset, you want to make sure there's an agreement, right? You don't want to start having these documents drafted only to find out there's a hang up and then going back to square one. So that's the next step, is after you figure out what your rights are and how you should approach this, then you got to make sure that you nail down the terms of the actual agreement. Once you and your spouse are on the same page, then we have document drafting, excuse me. And this is something that we do for our clients. We draft all of the documents, all of the filing documents, the divorce agreement, which is probably the most important document. And we also help our clients with their financial statement. Very important that you get that right, that it's accurate, because if it's not accurate, that's something that can come back to bite you later. So you got to make sure your financial statement's accurate, and the firm helps with drafting all of the documents you need for your uncontested divorce. Once the documents are drafted, we then send the documents to our client. Our client will review the documents, make sure that he or she is fine with them, make any suggested or give us any suggestions for edits, ask any questions. That'll help us nail down the documents, the language, make sure that we're all on the same page. Once we've done that, and once we have connected with our client to make sure that the documents are reflecting the actual agreement between the parties, then the next step is to send the documents to the other party, or if the other party is represented, the other party's attorney. They then review the documents, make any necessary changes. If there are any changes, any suggestions for edits, we then discuss. Once we nail down the agreement and everybody's in agreement with the content of the documents and the substance of the agreement, of course, and we have the financial statements filled out by both parties, signed by both parties, we then file the documents in court. Once the documents are filed, the court will then assign an uncontested hearing. So that court date will usually be anywhere from 3 weeks to a couple of months out, depending on the court's calendar. Some of these hearings are by Zoom. Some of them you have to go in person. That final hearing is the event at which the judge actually reviews the agreement. The judge will ask the parties some questions, mainly whether their financial statements are accurate, whether they have read and understand the agreement, and whether they need further time to discuss with counsel, and most people at that point say no. And unless the agreement is egregious or there are some real red flags, most judges approve it, right? If they feel like somebody's being taken advantage of, most judges will speak up under those circumstances and ask some questions. But for the most part, judges will approve the agreement unless it's really unfair. So what is the timeline for this? Well, we can typically get all of this drafted within about 3 weeks, within a month. It really depends on how quickly the parties communicate and get back to us. So if our client is responsive, if the other side is responsive and moves the process along, then everything can be drafted within 3 weeks or a month. Once we circulate it for signatures and we file it with the court, again, it's about another 3 to 6 weeks, 3 weeks to a couple of months before we get an actual uncontested hearing. And then once the judge approves the agreement, then the divorce nisi enters 30 days later, so 30 days after the hearing, and then the judgment and divorce absolute enters another 90 days from the hearing, so 120 days later. So what does that mean? Well, it's kind of a relic in the law. Nothing really happens during that time, during those 120 days. For the most part, you are divorced once the judgment of divorce nisi enters, but it's not technically final until the divorce absolute. So uncontested divorce, there's the divorce hearing, judgment of divorce nisi 30 days later, and you'll get a document with those dates, with kind of a summary of the terms of the agreement in terms of what remains open and modifiable and what's closed out permanently in terms of the issues. For all intents and purposes, you're divorced as of the judgment of divorce nisi, and then another 90 days after that, so 120 days from the actual divorce hearing, is the judgment of divorce absolute. So that's when you are technically and legally divorced. So that's how the uncontested divorce process works. If you have any questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can also find us on social at Farias Family Law. Thank you. Have a good day.